For stamp duty, next 2 points are depending on whether any consideration is there or not. The term consideration in contract law refers to something of value given to someone in return for goods, services, or some other promise. A valid contract must include consideration for every party involved. In simple terms, consideration is the basic reason a party enters into a legal contract, and this consideration is often monetary or sometimes other things also. But it can be a promise to perform a specific act or a promise to refrain from doing something. That means without monetary, there are other things also. In order for a contract or agreement to be legally binding, every party to the contract must receive some types of consideration. But we know without consideration a contract can be valid. And for this purpose, Stamp Act 1899 states that how much stamp duty needs to be paid. When an irrevocable power of attorney comprises immovable property is executed without any consideration as defined, authorizing the attorney to sell, to make contract for sale, or to execute mortgage deed in favor of a bank or a financial institution in respect of a loan, the stamp duty is 1000 taka. For an irrevocable power of attorney, it means which cannot be revoked except in rare circumstances, comprising immovable property, entitled to sale or transfer of land, and without any consideration, then the stamp duty is 1000 taka. That means for irrevocable power of attorney. That means for irrevocable power of attorney which cannot be revoked and that comprises immovable property and entitled to sale or transfer of land and which must be without any consideration, then the stamp duty is 1000 taka. Second one is when an irrevocable power of attorney is executed for consideration. That means with consideration, the stamp duty is 3% of the value of the consideration which is paid and the amount which is not less than 6000 taka and more than 60,000 taka. Next point is revocation of power of attorney. Section 11 of the Power of Attorney Act 2012 states the power of attorney will end in the following cases. Number 1, if the power of attorney is executed for a specific purpose after the execution of such work or performance, or for the purpose of making any special purposes it has been accomplished after having attained or acquired it, then the power of attorney will end. Number 2, after obtaining the power of attorney for a certain period or the expiration of that period, the power of attorney will end. Number 3, for irrevocable power of attorney, if the beneficiary is bankrupt or incompetent or died or the legal entity is dissolved in the case of power of attorney, then the power of attorney will end. The last one is to destruction of the contents or the existence of the power of attorney or the subject regarding the general power of attorney, the general power of attorney may terminate the power given by a power of attorney for 30 days by giving a registered post to the attorney and confirm that all the purpose attorney served those are lawful. So, the principal can revoke his or her power of attorney by giving a registered post within 30 days and confirm that all the purposes attorney served those are lawful. The attorney may also discharge the duty of the attorney from giving notice of 30 days through registered post. So, if attorney wants to discharge from his duty, then he can also do it by giving notice or by giving registered post notice of 30 days. Therefore, generally, a power of attorney may be revoked at any time by the principal or donor by giving a written notice to the attorney, unless it is for a particular fixed period. Revocation generally possible when principal dies or becomes insane or becomes bankrupt for irrevocable power of attorney. The principal himself can revoke power of attorney if the power of attorney for which the attorney was appointed is over as mutually agreed upon by the principal and the attorney. In such case, both principal and attorney can give termination letter by registered post and both parties will get 30 days for giving termination letter and for discharging from the duty of the attorney. Therefore, there are another few issues which are very important to keep in mind and to put on very carefully when you will go to prepare and to draft a power of attorney. First one, power of attorney by two or more persons. A power of attorney may be executed by two or more persons jointly in favor of one or more persons, and when they are several persons as attorneys, a complete authorization in letter to be given by one of them for acting severally. A clause should be included while drafting the deed of power of attorney that all the attorneys should act jointly or separately. So deed is very important, or the documents of power of attorney is very important to identify regarding the power of regarding the attorneys should act jointly or separately or for a specific purpose or different purposes. Next one is duration of granted power. A general power of attorney remains in force unless expressly revoked or determined by the death of either of the party. A special power of attorney will be in force until the specified act is not completed. Duration of the power will depend upon the type of the attorney or there may be a fixed period of power granted by the principal which must be included in the deed. So, duration is another important part and must be specified in the document of power of attorney. Next one is duties of the power of attorney holder. Duties of the attorney holder. An attorney holder is a person who is authorized by principal legally. An attorney must not exceed the authority given under the power of attorney. If the attorney does exceed their authority, he or she may be liable for any damages suffered by the donor or others. The attorney may, however, do all those acts which are authorized, but only by a particular method, if the power of attorney so indicates. If there is a breach of any condition by the attorney, then he shall be liable to the donor except in a case where he has acted reasonably. If there is some doubt as to the wording of the power of attorney, a principal should always be consulted. The attorney holder must also act towards the principal with the utmost good faith and tell the principal the nature and extent of any interest which may conflict with his or her duty. An attorney may pass on his or her powers and duties to another person not only if authorized to do so by the power of attorney. So, an attorney may pass on his or her powers and duties to another person only if authorized to do so by the power of attorney.